A revocable trust, like I said, it's revocable. If you can get it, your creditors can, so no creditor protective bubble. It can be used to provide flexibility, anonymity, ease of administration, avoid probate, all sorts of reasons, good reasons to have them, but creditor protection is not one of them, okay? And there are differences between the revocable trust for estate planning and what we do with a land trust. And I want to tell you a little bit about the revocable trust for estate planning so we can contrast the land trust to it in just a minute. So if you're setting up a revocable trust for your estate planning, you obviously write the document, or your lawyer does, and it is revocable. You, the grantor, the person who sets it up, also usually reserve the rights as the beneficiary, and you're usually your own trustee during your lifetime or during your competency. Then you name alternate trustees to kick in if you become incompetent or dead, and alternate beneficiaries. But during your lifetime, it's just like your own personal little bank account. You do anything you want to with it. You deed property into it on the public record. It shows your name as trustee, you know, all of that. The beneficiaries usually don't know they're even beneficiaries unless you've told them what your estate plan is. You know, my kids probably assume I'm leaving stuff to them until he throws another party and then he's out. But, right, honey? But they don't know the terms of it. He doesn't know that I've left it in trust till he's 95, and if he's still good then, he might be able to get enough for a pizza. Technically, he's a beneficiary. Just kidding, Jackson. But anyway. But I will say this, though, in the estate planning trust, and Jack, you won't like this very much, but you know, when I started my own estate plan as a lawyer, I didn't have any kids. I had no kids. So I'm working with a whole bunch of other people, and I'm drafting trusts for their kids. So when I come time to do my will or my revocable trust, I'm saying, well, when I'm dead, it goes in equal shares to my kids. And you know, the trustee can pay for their education and things like that, but when they're 25, they can get a third of it for any purpose whatsoever. And when they're 30, they can get half of it. When they're 35, they can get it all, right? No big deal. That seemed like a lifetime away. They weren't even born yet, right? Well, guess what? My oldest child is 25. And guess what happened to my estate plan a few years ago? 25 is not the minimum age anymore. It is now, I think it's probably 30, and by the time he's 29 and a half, it'll be 35. It's the beauty of a revocable, changeable trust. Now, my kids are all, except for him, no, he's good. They're all very responsible. My 25-year-old's the one living in Turkey, supporting himself, has been since college. It's not that I worry what he'll do with the money at 25, but he doesn't need it. And I'm not dead anyway. But, you know, and I don't plan to be for a long time.
Thank goodness.
Yeah, exactly. All right, so, I wanted to make one other point. With an irrevocable trust, it is a separate legal entity. What that means is it has its own tax ID number, it files its own tax return, and it probably issues a K-1 to the beneficiary in some cases, but it is a separate legal entity. A revocable trust is what we call a grantor trust, and it is ignored for tax purposes. Okay? It's not a separate legal entity. It does not have its own tax ID number unless you want to get it for like banking purposes or something like that, but it is not a separate legal entity. And this is not a CPA class, so we're not going to go into that in detail, but